Hi, welcome back to my YouTube channel Legal Voyage. Today I'm going to do a lesson on the principle of separation of powers in the United Kingdom. In this video, I'll be talking about these 3 points. What is separation of powers? What is the importance of separation of powers? And is there separation of powers in the United Kingdom? Let's go back to the history of the separation of powers doctrine. Aristotle in 4th century BC in his book The Politics recognizes 3 elements of a constitution. These are public assembly, office of the state and judicial department. This is the first time in the history that we can see the separation of powers doctrine was recognized. After Aristotle, in 1689, John Locke in his second treatise of government follows Aristotle's opinion, and he says if one person held all 3 roles it would turn any country to a dictatorship. Therefore, he strongly argued in favor of separation of powers and also recommended a system of checks and balances. We will talk about these checks and balances later on in the video. Also, Montesquieu in 1748 gave a modern definition for separation of powers. He said that every state should consist of 3 limbs, namely legislature, which makes the law, executive, which enforces the law, and judiciary, which interprets the law. So what is separation of powers? Taking into consideration all these traditional definitions for the separation of powers doctrine, we can say that it is a traditional division between executive, legislative, and judicial roles. It is a concept which protects individual liberty by ensuring that too much power is not concentrated into the hands of a single person or institution. So what is the importance of separation of powers? Firstly, if one person or institution holds all 3 roles, that is, executive, legislative, and judicial roles, it would result in a dictatorship and abuse of powers. Therefore, separation of powers is important to uphold the rule of law. For example, if you think about the Nazi regime, Adolf Hitler played all 3 roles. He was making laws, enforcing laws, and also performing the judicial functions. Therefore, it resulted in a dictatorship and abuse of powers. Therefore, we can say separation of powers is an important principle which upholds the rule of law. Also, it ensures the operation of checks and balances within institutions. Also, when various powers are allocated to the right kind of institution, it is likely to be exercised efficiently. For example, having a separation of powers in the judiciary will result in the judicial functions being carried out more efficiently. Is there separation of powers in the United Kingdom? As we know that there is no written constitution in the United Kingdom, there is no document which outlines the concept of separation of powers. Therefore, there is no rigid application of this principle in the United Kingdom. However, we can still find out the 3 limbs of the government, legislature, executive, judiciary, are in existence in the United Kingdom too. If we look at these 3 branches, we can see that there are overlap of powers. First of all, let's look into the constituency of each of these branches. The executive branch consists of the Crown, Prime Minister, and the Cabinet. The legislative branch consists of the Crown, House of Commons, and the House of Lords. Judicial branch consists of judges and lay magistrates. Now, looking at this itself, we can see that there is an overlap of powers because the Crown is both in the executive and the legislative branch. Then the Prime Minister and the Cabinet, who are members of the House of Commons, are part of executive and the legislature. Also, the House of Lords is part of the legislature and the judiciary. So the constituency itself shows that there is an overlap of powers. Another overlap of powers can be seen in the role of Office of Lord Chancellor. He occupied power in all 3 branches, and he used to be the Speaker of House of Lords and the head of judiciary. However, the Constitutional Reforms Act 2005 reformed the powers, and the Lord Chancellor is no longer occupying roles in all three branches. Also, the House of Lords carried out both judicial and legislative functions, but the Constitutional Reforms Act 2005 established the Supreme Court, and no longer House of Lords sits in the legislature. The Prime Minister and ministers of the executive branch can sit in the Parliament. As we saw, Prime Ministers and ministers were part of the legislature as well as the executive. So this is also an overlap of powers. The ministers legislate through secondary legislation or delegated legislation. So ministers perform the functions of the executive as well as the legislature. Let us now see some checks and balances exercised within the three branches of government. Judicial review of executive decisions. The judiciary is given the power to review all the executive decisions. So this is the judiciary exercising checks and balances over the executive. Also, the Declaration of Incompatibility under Human Rights Act 1998 by the judiciary allows the judiciary to exercise checks and balances over the executive decisions and the acts of parliament. However, the executive is not bound by such a declaration. They may take it into consideration when passing an act of parliament. The question time and parliamentary debates gives a chance for the legislature to exercise checks and balances over the executive actions. Also, the legislature can criticize judgments under parliamentary privilege. Removal of judges by a vote of no confidence in the parliament shows that the legislature has power to exercise checks and balances over the judiciary. In conclusion, we can say that there is no rigid application of separation of powers in the United Kingdom, but the Constitutional Reforms Act 2005 has taken a step forward to ensure a better application of this principle. Reformation of the Office of Lord Chancellor, establishment of Supreme Court of UK, establishment of Independent Judicial Appointments Commission, and ensuring the independence of the judiciary are some of the steps taken by the Constitutional Reforms Act 2005 to ensure the application of separation of powers doctrine. Separation of powers does not aim only to separate different functions, but also to ensure that there are checks and balances within the government. A complete separation is bad as no separation of powers. I hope you got a clear understanding as to what is separation of powers and how it applies in the United Kingdom. Subscribe the channel for more lessons like this. Thank you.